We continue with the motion hearing, July 5th, 2006. The court. At this time, we're back on the record. All counsel are present. And I believe that, with the exception of some testimony we're going to hear on one of the July 19 motions later this afternoon, we have completed the evidence portion of the hearing today. Is that correct, counsel? Attorney Kratz. Judge, there may be some brief testimony as to the bond modification motion of Mr. Strang that we intend to come much later this afternoon, once that motion is addressed. The court. All right, moving on to the motions themselves. And before dealing with the particular motion, I know there was a number of motions and supporting documents filed under seal. And it's my understanding from our status conference leading up to today's hearing that the parties were going to request that a number of the documents that had been filed be unsealed. Is that correct, counsel? Attorney Strang. I don't know that it's a great number. The principal issue, at least as I recall it, Your Honor, was the defense motion to exclude the Manitowoc County Sheriff's Department, which I filed under seal in deference to Mr. Kratz's expressed view that it ought to be. So I thought it only fair to honor that in the first instance, and then to let the court decide rather than, in effect, deciding it myself by filing it other than under seal. I don't think it's properly sealed. That is, I couldn't defend a media request to unseal it. It concerns information that already has been broadcast publicly. And in general here, Steve Avery is aware that the public nature of trials in this country has been an aid to the defense. It's been a protection for the citizen accused, and I would err here on the side of making court documents publicly available where they possibly can be, and certainly there still will be some that cannot, consistent with the fair trial and the court's obligation. But I think this one reveals nothing that hasn't already been broadcast publicly by Fox 11 TV. So I suggest to the court that the motion to exclude the Manitowoc County Sheriff's Department and any response from the state rightly ought to be unsealed. The court. All right, Mr. Kratz and Mr. Fallon. Attorney Kratz. Judge, I do agree with Mr. Strang's position on that particular motion. Our concern was providing an additional forum for additional pretrial publicity on such a volatile issue, or at least as framed by Mr. Strang. But at this time, as the matter has been brought before the court, and the court is about to receive at least brief oral argument on it, I have no objection to that course. The court. All right. The court will order then that that motion and any papers filed in support of or in opposition to it can be unsealed. The next item I have got is the state's motion concerning third-party liability evidence, or a Denny motion. Is there any reason that that pleading and the briefs submitted in support and opposition to it cannot be unsealed? Attorney Kratz. It's fine from the state's perspective, Judge. The court. Mr. Strang? Attorney Buting. Judge, I'm handling that motion. I don't know that it was actually originally sealed, but I don't see there is any need to have it sealed or any of the responses. The court. Okay. Court will order that motion and the briefs relating to it unsealed. The next item is, well, actually, the state, I think, groups together a number of preliminary motions in limine. The one that I'm looking at to be dealt with next is the motion concerning the admissibility of evidence regarding the defendant's wrongful conviction. This would be designated as item 1 in the pleading entitled Motion in Limine Series 1 from the state. Now, there's other related motions made in the same document. I will start out, I guess, Mr. Kratz, with you, since you filed it. Is there anything in there that the state feels requires sealing at this point? Attorney Kratz. Not in paragraph, I'm sorry, Judge, not in paragraph 1, no. The court. Well, let's take the entire document. I don't think I can unseal a paragraph. I think there is later in the document some evidentiary matters that are set forth in some detail, the admissibility of which yet to be determined. Attorney Kratz. Paragraph 5 and 6, Judge, may still be appropriate to be sealed, as it requires, at least in part, a balancing test of the court and seeks a pretrial ruling of the court. As I told the court in chambers and Mr. Strang, paragraph number 7, dealing with out-of-the-court statements of Teresa Halbach, this court understands that recently decided case of Davis v. Washington, decided by the U.S. Supreme Court June 19th, was very relevant to the analysis the court must undertake in this regard. The court had asked for a supplementary memorandum of law to be prepared. I have done that. I have provided that to defense counsel. I at least want to provide the court the original of that, although it's not going to be argued until the 19th. That's been completed, Judge. The court. All right. What's the state's position on the sealing or unsealing of the state's Series 1 motions in limine? Attorney Strang. Defense's position? The court. Defense's position, I'm sorry. Attorney Strang. This is an appropriate case to use redacting of a public copy rather than sealing. And I think that paragraph 1 may be made available publicly, that is, not redacted. Paragraph 2 may be made available publicly, not redacted. Paragraph 3, I think, is appropriate for public disclosure, not redacted. Paragraph 4 need not be redacted. Paragraph 5, in my view, need not be redacted. All of paragraph 6 should be redacted at this point. Paragraph 7 need not be redacted. The argument that follows need not be. And then paragraph 8 need not be redacted. The court. So the defense is asking for the document to be unsealed with the exception of paragraph 6 being redacted, correct? Attorney Strang. I'm sorry? The court. Paragraph 6 is the only one that you are asking to be redacted? Attorney Strang. Yes, Your Honor. The court. Any objection from the state? Attorney Kratz. No, Judge. Other than there was discussion previously about paragraph 5, and this court asking for additional argument as to that may or may not include information that will be made public. Actually, the suggestion or offer in paragraph 5 is probably not something that is all that noteworthy, and so I would have no objection to the court, other than paragraph 6, allowing this document to be made public. The court. All right, let's move on then to Attorney Strang. May I make a suggestion? The court. Yes. Attorney Strang. About the mechanics of this, which would then apply to any future issue where the document itself would be public, but parts of it may be redacted. My suggestion would be that the author of the document, in this case the state, go back to the word processing system, create a copied over document of this, and then just remove paragraph 6 and put paragraph 6 redacted, rather than black ink and that kind of thing, which people then invariably are holding up to the light and trying to guess about. I think it's just a more effective way to redact. And then the document, as refiled, would clearly say redacted at the appropriate paragraph. And I, of course, would have there's every reason why a redacted copy should be treated as filed on the original date of filing, nunc-pro-tunc. The court. Any objection, Mr. Kratz? Attorney Kratz. My secretary might, Judge, but I don't. We'll try to accomplish that. The court. All right, let's move on then to the next item to be addressed today. That was actually, I think an additional part of the same document, which would be paragraph 3. So that's dealt with there. Attorney Buting. Judge, the only filings on that motion so far is the state's motion in limine series 1 that we just discussed, paragraph 3, and then my letter response. I don't think that needs to be sealed. The court. Okay, all right. So, well, that's a good point. The written arguments in support of or in opposition to the request for each of these items, with the exception of paragraph 6 at this time, I would think could be unsealed or submitted open, if you will, without prior request to and permission of the court. Fair enough? Attorney Strang. Right. And in that vein, I filed a memorandum that relates only to paragraph 6 and the state's argument there. So my memorandum probably just could be sealed. The court. That would remain sealed. Very well. The court was also going to take up paragraph 2 of the state's motions in limine today, and that's covered by the part that has already been decided to be unsealed. Attorney Strang. And that's a matter on which I have no doubt will reach a substantive stipulation at some point. The court. The state's motion to dismiss, I believe, is already open. I don't think there's anything left to unseal there. Is that correct, counsel? Attorney Kratz. The defense motion, I don't think I filed one, Judge. The court. Right. Attorney Strang. Right, I think that's unsealed. The court. And then there were also a defense motion concerning interference with right to counsel that I had led to believe might be resolved by today relating to the other person. Attorney Strang. The cellmate? The cellmate? The court. Yes. Attorney Strang. It's not even a motion, it's a notice. The court. True. Attorney Strang. What I'm awaiting from the state, and I'm sure I will get when Mr. Kratz has 5 minutes, is an explanation of why this gentleman was in the jail at all. CCAP doesn't disclose a reason. I know that Mr. Kratz knows, and he's commented about where the gentleman is now, so he has that information. At this point, I wanted the state and the court to be on notice that we have a concern about cellmates and inquiry that may be made of Mr. Avery by cellmates. But as the notice itself says, I think at this point there hasn't been a, quote, Messiah problem, unquote, that arose to that gentleman. The court. Mr. Kratz, do you have material with you today that are hopefully going to resolve that? Attorney Kratz. I have information. Actually, if the court anticipates a mid-afternoon break, Mr. Wiegert from the Sheriff's Department can provide that relevant information, and I'm sure it will be to Mr. Strang's, or that it will conclude the matter without further discussion with the court. The court. All right, the last item up for consideration today is the defendant's motion to reduce bail, which was already, I believe, submitted under seal. What's the position of the parties on the particular motion? Mr. Strang? Attorney Strang. This is Mr. Buting's department. The court. Okay, sorry, Mr. Buting. Attorney Kratz. We're just talking on the sealing issue? The court. The sealing issue of the bail motion, correct. Attorney Buting. Judge, I have no reason that this could not be unsealed. The court. What is the state's position? Attorney Kratz. Well, Judge, this was what we had alerted the court that would require some brief testimony. It deals with statements made by a co-defendant, which may or may not be admissible at trial. Quite frankly, Judge, the state doesn't mind if it's unsealed and discussed. We can certainly do that in open court. As an officer of the court, however, I need to alert the court, and I'm sure defense counsel understands, that portions of those statements may or may not be admissible. So I want to at least tell the court that. If we're getting into those statements, we can certainly do that in open court. That seemed an area, however, that was a little less clear about whether the court wanted to air that in open court. But we're prepared to do so today if the court wishes. The court. Mr. Buting? Attorney Buting. Again, I'm fine with unsealing it. I don't think there's any reason that it can't be. The court. Very well. The court will allow that motion to be unsealed, and I will prepare an order regarding the documents to be unsealed, which I will submit to the parties before I sign it, just so everyone is in agreement. Attorney Strang. There's one more document that's under seal, Your Honor. The court. Okay. Attorney Strang. I filed a motion to suppress Mr. Avery's November 5 statement to the Marinette County Detective and any products or fruits of that statement. The motion itself was not under seal, but I filed a supporting affidavit from Steve Glenn that has some pages from the discovery attached to it, and therefore I filed under seal Mr. Glenn's affidavit, because it was my understanding if we were attaching discovery documents, it should be filed under seal. All that said, I don't think there's nothing all that terribly prejudicial in the discovery documents that were attached to Mr. Glenn's affidavit. So I don't feel strongly about keeping it sealed. The court. Mr. Kratz, Attorney Kratz. I have no objection to that as well, Judge. And I didn't know if the court wanted to deal with the July 19th motions as well. This Marinette issue is to be dealt with, at least contemplated, partly today and partly on the 19th. And I noted the court did not address other motions, including the other acts motions, which I'm sure should remain under seal. But that having been said, I don't have any objection to the Marinette detective's reports, or at least portions of them included in Mr. Glenn's affidavit, to be made public. The court. Very well, I will conclude that as part of the order then. Attorney Strang. Mr. Buting points out that there is one more document that remains under seal, which is the Defendants' Memorandum on Evidence of Wrongful Conviction and Accusations of Prisoners. The court. That sounds like it would fall under paragraph 6 of the Attorney Strang. Some of it does, and some of it concerns paragraph 1. I was pretty circumspect in what I have said about the paragraph 6 material in this memorandum, although I did file this under seal. I don't have an objection to unsealing it, and indeed, maybe a good balance to strike here is there's probably about 4 lines of it that could be redacted with the rest of the document being unsealed. And obviously I, as the author, would handle the word processing tasks that I described earlier. If the state would prefer that it not be redacted, then I don't have an objection to unsealing it in its entirety. The court. Mr. Kratz? Attorney Kratz. I don't have a position, Judge. I think Mr. Strang is correct. There isn't anything in there that's so prejudicial that it needs to remain sealed. The court. All right. I will include that as part of the court's proposed order. Do the parties have a preference as to which motion they wish to present argument on first? Attorney Kratz. Is the court contemplating receiving argument on the change of venue, exclusion of the Sheriff's Department, and motion to dismiss? The court. Yes. Attorney Kratz. Altogether, or did the court want to receive separate argument on those? We certainly can, since we meaning defense counsel and the state, have in one form or another presented the lion's share of the argument to the court. I expect this court wishes a very brief summary of the arguments as to those. I have no objection, Judge, to providing them en masse, that is, all 3 together, since they are interrelated. The court. Mr. Strang, are you going to be arguing these for the defense? Mr. Strang. I am. The court. Any objection to combining your argument? Attorney Strang. I don't. The court. All right, you may proceed. Attorney Strang. I will start with Mr. Avery's motion to dismiss the 5 counts relating to Teresa Halbach. I was clear on the motion, but I will reiterate here that we have not moved to dismiss the felon in possession count. But I don't think the problems of which we complain relate anywhere near as strongly to that count of the amended information. In fact, the facts here largely are undisputed, Your Honor, in terms of what has happened. but I will simply review them as I understand them. There have been 8 news conferences of which I'm aware in this case. All 8 of them have been set up by the state, presented by the state, as part of a decision, as Sheriff Poggle testified this morning, to disseminate information to the media and thereby to the public, and to do so with control of the Calumet County Sheriff and the Calumet County District Attorney, who serves here as special prosecutor, of course. Each of those 8 news conferences was broadcast in full by one or more, I think probably all, of the Green Bay television stations. Some of them were covered in full or in large excerpt by Milwaukee stations. The defense appeared at none of those, and there have been no news conferences called by counsel for the defense at any juncture, either current counsel or, to my knowledge, predecessor counsel for Mr. Avery. Of the state's 8 televised news conferences, 4 of those came after formal charges, or a formal charge was filed against Mr. Avery. The court will have available to it DVDs of all 8 in full, but I will represent to the court, as an officer, that Stephen Avery by name, and then the Avery family more generally, are discussed in all 8 of the news conferences. Some of that incidentally, some of it in response to questions from media people, some of it just in the statements of Mr. Kratz or Sheriff Poggle. And, to be clear, obviously, it's conceded by the defense that the locus of much of the investigated activity here was the Avery Auto Salvage property. So I don't cast aspersions or lay motives in and of itself to talking about the Averys or the Avery family or the Avery property that was the locus of many of the investigative steps here. But it is clear that the Avery name, and Stephen Avery's name in particular, was attached immediately in the news conferences, and then consistently in the news conferences to the information that the state was making public. That included, at the March 1st and March 2nd news conferences, the impetus of which we are told was the arrest, and then the plans to charge, and eventually the charging of Brendan Dassey. Impetus that may have been for the March 1 and March 2 press conference, but again, much of the content of both of those concerns Stephen Avery. There have been claims of superior knowledge made, salted throughout these various news conferences by either Mr. Kratz or Mr. Poggle. And I don't remember right now anyone else speaking at them, although I can't be certain. Well, I take that back. I think Manitowoc County District Attorney Mark Rohr spoke very briefly at one of them. And I know that others appeared on camera, but I don't recall them speaking, all of them law enforcement officers or representatives of the state. So not at every one of these conferences, but salted throughout, there are references to what the state now knows, or what is now clear, and assurances to the public that law enforcement and the prosecuting authorities were in possession of information beyond that disclosed to the public, and that they found, or viewed, the information known only to them as reliable and as informing their conduct and their decisions in this case. One of the press conferences, March 2, 2006, was sufficiently graphic or lurid or colorful in its details that Mr. Kratz did something I had not ever seen before, which is at the beginning urged children under age 15 and friends or family members of Ms. Halbach not to watch. Essentially, the state made an effort to impose an R rating on its final televised news conference here on something that it knew was to be broadcast in the media market covering this county, and therefore the jury pool during daytime hours. There have been at least 2 other appearances by law enforcement figures on TV. One, a televised interview of Sheriff Poggle, as I recall, and that was the topic of some brief testimony by him earlier this morning. And then probably something that's drawn much more focus, a 2-part series run by WLUK-TV, which is Fox 11 out of Green Bay, that featured prominently, although not exclusively by any means, Sheriff Kenneth Peterson from Manitowoc County, who, it is undisputed, personally has next to no role in the actual investigation of this case, but who spoke as the chief law enforcement officer at the county level for Manitowoc County. That was aired 2 nights in a row, May 10 and 11, and I think the court has already a DVD carrying the 17 plus minutes of those 2 segments. I note, as well, that one of the earlier steps that I took after undertaking representation of Steve Avery was to move for what we call locally a gag order. The motion had a little bit more elegant title than gag order motion, but the gist of it was that I was moving to limit public comment. From my recollection, and I'm sure the court's notes or recollection are to be relied upon at least as much, if not more than mine, and the public record here. But my recollection is that the state did not join in that motion, and the court, after some prompting to the parties to try and work things out in a reasonable way, eventually denied the motion. The defense also here has sought an adjournment of the trial date, initially set for September 5, an October 16 date was proposed. The defense position, in a nutshell, was October 16 was better than September 5, but not sufficient, and that we thought an adjournment date into 2007 was necessary for adequate defense preparation and to permit a diminution in the publicity, and particularly the more inflammatory publicity that has attended this case from the outset, as Sheriff Poggle correctly anticipated back on November 5. The state, as I recall it, agreed that on balance it was appropriate for the court to adjourn the September 5 trial date, but the state preferred an October 16 trial date. And as we stand here today, it's the October 16 date that the court has scheduled for the trial on this. So I don't think there is any question that the publicity has been intense here, that at least to the extent of the 8 news conferences and a couple of other televised appearances that I have described, that the state has participated actively in that. Indeed, made a conscious choice to engage in the dissemination of information that way, publicly, as Sheriff Poggle testified this morning. And that a foreseeable result of that would be to impair or threaten, put at serious risk Mr. Avery's right to a fair trial at all, because some of this publicity has been statewide or even national, as the testimony acknowledged this morning. More specifically, has imperiled, put at risk, Mr. Avery's right to a trial at which citizens of Manitowoc County would serve as jurors. Both of these are constitutional rights that he has, the fair trial in general being both federal and state constitutions, as providing the basis for those constitutional claims. And as to a trial in this vicinage, or a trial venued in Manitowoc County, the Wisconsin Constitution guarantees Mr. Avery that right. Now, I don't disagree with the state's observation in the abstract that sometimes constitutional rights come into tension with one another. Sometimes one, a defendant and accused, is put to a choice in, do I, for example, exercise my constitutional right to be heard at trial as a matter of due process by testifying at trial, or do I exercise my 5th and 14th Amendment, and for that matter, state constitutional privilege against self-incrimination by declining to testify, knowing that the state, then, can't comment on my decision not to testify and meet the charges. That would be the classic dilemma or a potential conflict of constitutional rights. The defendant who chooses to testify necessarily gives up the privilege in self-incrimination. The defendant who stands on that privilege necessarily then can't testify in his defense at trial and exercise that aspect of his due process right to be heard. But that's not the kind of conflict of constitutional rights that the court confronts this afternoon. That is, the constitutional rights we raise here. The right to a fair trial, the right to a trial in the venue in which the crime is alleged to have occurred, are not unavoidably in conflict, as are self-incrimination and the right to be heard. And this isn't a situation where mere fate has caused these two constitutional rights to collide, where forces outside anyone's control, or as I say, fate, for shorthand, have put Stephen Avery to an unhappy choice. This is not fate. This is the state that has done this. The state has fostered the publicity. The state has contributed to the publicity. The state is not to blame for all the publicity, and I don't suggest for a moment that the state is. Today, we're being televised, I assume, or there will be newspaper reports about the proceedings today, and that's not attributable to the state. It doesn't lay at their feet. I haven't attributed any fault, any wrongdoing to the Halbach family. They have entirely separate interests. Those interests are important. They are legitimate. They are not under the state's control. And nobody is complaining here about statements that the Halbach family have made, or when they have been intruded upon by cameras, the way they've handled that. Although there has been other publicity. So the state, the state is responsible only for some of the publicity in this case, but that responsibility is significant. When I looked around at cases, primarily on change of venue, I find references to, one short informational news conference, for example, Briggs, the defendant not mentioned by name, purely an informational short news conference. Now, I can't say that there's no reported case in which there's been more than one news conference. I haven't seen one, but there may be one. Even in the state courts of Wisconsin, I'm sure if I cast a wider net, nationally or in the federal decisions, I'm sure I would find situations where there have been more than one news conference held by the prosecution, the state, the government, but 8 is a great number. They were televised, and these were not purely informational. These included a great amount of detail, a fair amount of opinion, assertions of knowledge, as if that epistemologically were absolute, and based on information not to be disclosed to the public. In the case of March 2, the presentation was so graphic and I think effective to give Mr. Kratz his due that he himself warned some viewers not to watch, and gave what I thought was a pretty effective opening statement or closing argument, running through the criminal complaint that was graphic and highly detailed, a criminal complaint that went well beyond what was necessary to establish fair probable cause against Mr. Dassey, in the information that it detailed, and then that Kratz repeated on television. The participation of Sheriff Peterson hardly needs much further comment. I will go out on a limb and say that we will not find, in reported decisions, another case in which the sheriff of the county in which the alleged crimes occurred opines not just that the defendant is guilty of the charged offense, but opines that if he's acquitted, somehow he will murder someone else in the future. On what possible basis, I have no idea, that assertion would be made. I will venture further that the court will not find a close analog to the chief county law enforcement officer in the affected county describing with or agreeing with a description of an accused person as a psychopath, and then suggesting further in his own words, in a case having nothing to do with fraud, deception, that sort of wrongdoing, that the defendant may be a con man. This was really remarkable. Before we even get to the bizarre discussion of how it might have been easier to kill Stephen Avery than to frame him. Off the charts. And the direct participation of the sheriff of this county, his words, his image on TV, 2 nights in a row, in an interview that he said took about half an hour, that occurred in the second half of April, about 5 months into the prosecution of this case, and at that point, almost 4 full months before the September 5 trial date that this court anticipated. I will add also the interview being given at a time when the defense already had made clear that we prefer, We want a jury from Manitowoc County to hear this case. So the conflict here is constitutional rights. So the conflict here in constitutional rights, the fair trial right, bumping up against the right to a trial in the proper venue, isn't one of fate entirely. There has been significant state action in creating that conflict. It's a choice to which the defendant ought not be put. Because when the state takes action to interfere with any constitutional right, yet alone to bring two constitutional rights into direct contact so one cannot enjoy the one if he claims the other, the state is interfering with the defendant's constitutional rights, his bundle of trial rights assured by a federal, in part, and the state, in full, Constitution. And that's a denial of due process, it seems to me. I don't know what could be more fundamental to due process and to fair play than the state not interfering with or impeding or imperiling the defendant's constitutional rights, particularly when they go directly to where the trial will be held and how fair that trial will be. It's a fundamental denial of due process in addition to an interference with the specific constitutional right at issue. That's, I think, what we have here. Dismissal is an extreme remedy. But we have also seen extreme conduct. And if I thought there was some remedy short of dismissal, I understand just how unpalatable that is to the public, how horribly unpalatable that is to the Halbach family, if they believe Mr. Avery guilty. I understand how unpalatable that is to the court, which sits as the neutral in this, but in all events sits to see that justice is done, which ordinarily means that causes are tried. Allegations are presented to a fact finder, and they stand proven or unproven, but they are tried. So I understand this is unpalatable stuff. Maybe I'm not smart enough to think of the lesser remedy that would remove the conflict between the right to a fair trial and the right to a trial in this venue. The only alternative I have come up with, and I stand on, is to adjourn this trial for a number of months, into February 2007, and to couple that adjournment with an order limiting the public disclosure by lawyers in this case and by law enforcement agencies involved in the prosecution of this case. I think the court has the power to do that. It's unusual to ask for an order limiting disclosure by law enforcement officers, but the court in general has the right to control what witnesses say, and the court has the right to preserve the integrity of the proceedings before it and to assure the rights to a fair trial that he enjoys as a matter of the Constitution and that the public enjoys as a matter of common sense, as a matter of tradition in this country. And although it's not a constitutional right for the public or the state, it's certainly a tradition and a hope and aspiration in this country that the public, too, would have a fair trial. So maybe an adjournment coupled with an order limiting disclosure, but I don't have more to offer, short of dismissal of the affected charges. And again, I try to tailor that as best as I can to the problem. So the first course, the one I prefer, is that the 5 counts relating to Ms. Halbach be dismissed without prejudice on the hopes that at some point, if the state wishes to proceed, again, that could be done without irreparable harm to the constitutional rights of the accused. As a matter of second preference to adjournment, coupled with a pretty strong order eliminating public disclosure, that order would exclude the Halbach family. They would not be covered by it. And that order would exclude the defendant himself, because I don't think a court can or should mute the accused himself or has everything at stake in terms of his liberty, anything more than I think the court should mute or gag the family of someone who's been killed, who's been lost, because that family has a great deal at stake emotionally and in seeking justice. But I will say this, that I think Mr. Avery has been less voluble since Mr. Buting and I have arrived on the scene. Specifically, None of the Avery family members agreed to comment for the Fox 11 report, for example, as the reporter, Lauren Cook, notes at the end of both of those segments. I know that I have tried to keep my tongue in check with the media, not with 100% success, but I haven't had any news conferences. And while it wouldn't be proper for the court to order Mr. Avery to say nothing in asserting his innocence, I will say, if he says anything, he's got his lawyers to explain that to, and he understands we won't be very happy. So those are the alternatives. The third, and to us, least palatable alternative, is to change venue entirely in this case. Our motion is for relief under Section 971.22 of the Wisconsin statutes. It's not an invitation to, or an invocation of, the use of Section 971.225. We think that if venue has to be changed as a least palatable alternative here, that the entire trial ought to be moved to a less tainted county, in the hope that the jury there would not have to be sequestered and that we wouldn't visit that sort of imposition on 12 or 14 or 15 or 16 citizens, depending on the number of alternates the court might pick for a trial that well could go 5 weeks or conceivably longer. So I prefer the dismissal. Failing that, an adjournment coupled with the restriction of public comment by law enforcement officers as well as lawyers. And only last would I address change of venue. Now, I have more to say about the change of venue, but I want to end for the moment, in talking about an adjournment. And this is new. I have something new to say on that. I have not put this in writing, and I have struggled with how to say it, when to say it, and whether to say it, but I'm going to say it. The Wisconsin legislature, acting rather rapidly on the last day of a special session, saw fit to decree that on this November's ballot for statewide and federal offices, the citizens of Wisconsin will be asked to give their advice, if you will, to vote, that is, on an advisory referendum on the death penalty. Wisconsin has gone 153 years without the death penalty. No state in the nation has an unbroken period of that length in administering justice without killing people. That referendum will happen just about the time the state is resting its case, give or take a few days or a week if this trial remains set for October 16th. And in a state where, for example, in 1917, a bomb blew up and killed 9 members of the Milwaukee Police Department, in a state that produced Ed Gein in the 1950s, in a state that produced David Spanbauer in this neck of the woods in the 1980s, in a state that produced Jesse Anderson, who was cynical enough to blame his own murder of his wife on a young black man, figuring that would be the easiest guy to frame, in the state that in the 1990s featured Jeffrey Dahmer, in a state in which this horrible alleged crime probably isn't even the worst Halloween crime in this part of the state, I guess that honor would probably go, dubious though it is, to Gerald Turner in the late 70s. In a state with this history, Stephen Avery now has become the poster child, the poster boy for some politicians in pushing the death penalty referendum. Whether they like it or not, to some degree, Teresa Halbach's life and death have been politicized with the death penalty. And I tell you, I don't like it that Stephen Avery, for whom I feel responsible for here, has become politicized with the death penalty. But that's how it's playing out. That's what's happening in our state capital, and that's the reality in terms of the referendum the citizens face this November. And they ought not be going to the polls in the superheated atmosphere that this trial will produce, at least in the Manitowoc County and northeastern Wisconsin area. His own jurors shouldn't be taking a day off to go vote on the death penalty referendum at about the time that they've heard the best the state has to offer in this case, and probably before the defense has been heard, or heard in full. It's an unfortunate confluence. No one in this room is to blame for any of it, I hesitated to address it. The one, I feel very strongly about the death penalty in general. And two, it's just one of these events out there in Wisconsin. But the fact is, and you see this, if you go through the media reports that I have assembled for the change of venue motion, the fact is that politicians and the media themselves have linked the death penalty referendum to the prosecution of Stephen Avery. Senator Lassie from Dept, the principal sponsor of the death penalty referendum, said in televised interviews that he revised the wording that he had intended. He adjusted course on his referendum proposal because of the Stephen Avery case, or the Teresa Halbach case. I don't remember whether he used her name or his, and they are unfortunately linked by this case. But it was this set of events that brings to the courtroom that caused the principal author, he said on television, to revise his proposal. And this case simply is a link to it. It is not good democracy in terms of this referendum, and it's certainly not good justice in this particular case to have these two things going on at the same time. So, in speaking on behalf of an adjournment as the second of the three possible alternatives I have proposed here, I will close with that. If we get to the change of venue issue, the court wanted me to be more specific about what was prejudicial about the publicity, and also to make a full record by submitting what I have gathered on the publicity, and I will do that. But I'm going to yield the floor to counsel for the state on the initial matters I have addressed the court. All right, Mr. Kratz, will you or Mr. Fallon be addressing? To be continued.